Page North Star Realty, and welcome to your listing documents video walkthrough. I have found these very helpful. The documents contain a lot of legalese and technical vocabulary that sometimes can be distracting. If we're sitting in person to sign documents, it's very difficult to go through and sometimes can take a really long time. I have found it very easy if I send you this video and the attached copy of all of these documents. You can go through them yourself in about 20 minutes, depending on how fast I speak. It could be 25. And get a better understanding for what you're going to be signing. So when we actually sit down to sign, you're focused on that rather than a bunch of vocabulary and legalese you're not used to. Also, you can send me over any questions you have prior to me coming over to sit down with you, and we can go through them ahead of time. So hopefully I've answered all the questions and we can focus on the task at hand when we get there. Our first document is the Disclosure of Representation Trading Services document. This document explains the differences between working with an agent and not working with an agent. If you're working with an agent, you are working as a client. If you are not working with an agent, you are as a non-client. It's a very simple document to understand. You get 4 things with an agent. You don't get those 4 things without. With an agent, you are owed a duty of loyalty. Your agent only acts in your best interests. You are owed a duty of full disclosure, which means your agent must tell you everything they know that might influence your decision on a transaction. You have a duty to avoid conflicts of interest. So we must avoid any situation where that would affect my duty to act in your best interests. Sometimes where we see these come up is if I had a buyer who wanted to purchase your property. We hope those don't come up, and I can explain to you a little bit later on how that would work if that happens. It hasn't happened to me yet, so let's keep our fingers crossed that it doesn't. And duty of full confidentiality. I can't disclose any of your private information without your permission. Even after our relationship ends, so it lasts forever. The 5th one that's not listed here anymore is duty to obey your lawful instructions. Anything you tell me to do that is legal, I am obligated to do it because I'm acting as your agent. If it's illegal and unlawful, if you tell me to do it, I'll probably say once, I can't really do that. It's against the law. If you tell me a second time, we probably can't work together because I can't do anything illegal, and that's not going to work. So as a non-client, you get no loyalty, no duty of full disclosure, no duty to avoid conflicts of interest, and no confidentiality. The people at BCFSA want you working with realtors. They want third-party negotiations. They want the protection that we have of errors and emissions insurance, and they don't want to put the public at risk. Agents are protective. We work in your best interests, and we keep you from getting into trouble. So, at the 2nd page of the document, I will X here that I'm representing you as my client. I will sign here. I will date here. And your name or names will show up on the bottom here. You will initial that I have shown you this prior to signing any contract, and the dates will come up. Next document is privacy notice and consent. This document explains why we collect your personal information. There are 2 reasons. One is to list the property. So we have to get a copy of the title. Your personal information is on there, that then gets added to the listing, which can only be seen by realtors. And then all of that personal information is only seen by people who are either trying to purchase your property or once we have a firm sale on the property, people who are responsible for helping convey it. So everybody at my office, everybody at the buying agent's office, and both sets of lawyers will get access. Nobody else will. The other reason we collect is for FINTRAC, which is an anti-terrorism organization. I'm going to send you over an email from a company called Really Trusted. It's going to be an identity verification. I know you're not a nefarious character, but the government wants to verify it. So what this Really Trusted app does is it allows you to send in pictures of both the front and back of a driver's license, records all the information, does an identity check on you, makes sure that I'm not going to get any trouble for working with you, and you're not in any trouble that you don't already know about. And that's basically what this form tells you, is why it gets collected. Now, we're going to initial the bottom of this page. The 2nd page is what are called opt-outs. So these are if you don't want any of these things, A, B, C, or D, to happen, you can initial. I have never had anybody initial A or B, but you can have a read through them. C, other realtors may communicate with you to determine if you require additional real estate services. Lots of my clients initial that. And D, the boards and other realtors or their brokerage and survey firms on their behalf may communicate with you to participate in surveys. Generally, most of my clients don't want to participate in surveys, so we initial there. Your names will be printed, you will sign, you will date, and that form is done. It's very simple. The next form is the multiple listing contract. This is the most important document of this set. So your names and address will be here. You can see it says Royal LePage Little Oak Realty. They bought North Star Realty, so for the purposes of the sample, I have their name on there. It'll say Royal LePage North Star Realty. It'll have my office's address and telephone number here. Listing authority and term. So this is when the listing goes live on the market and when the listing expires. Generally speaking, minimum is about 90 days. We see some listings go for 6 months, some listings go for a year. It just depends on pricing strategy and marketing strategy and how comfortable everybody is with the process. So most of my listings are 90 days, and then we either relist or extend the listing if we haven't sold yet, and hopefully in that 90 days, if the market's good, we've sold. So item B here, so the seller authorizes the listing brokerage to obtain information concerning the property from any person, corporation, or governmental authority, including any mortgagee and British Columbia assessment, and to share this information with other parties, including members of any real estate board. So these just say that you're allowing me to do everything I need to do to get the property to market. You can see you're allowing me to put a for sale sign and sold signs on the property, and allow the cooperating brokerages and with written consent of the seller, a sub-agent of the brokerage to show the property to prospective buyers. So basically you're going to allow me to get all the information I need to list it. You're going to allow me to list it. You're going to let me put a sign up, and you're going to let buyers agents bring their clients to show the property. All very simple stuff. This will be all the pertinent property information. So here's your address. There's going to be a property identifier number. That's specific to every property. You'll probably see it on your property taxes. If you've ever looked up on BC Assessment, it's on there as well. It'll be on title. When I pull the title for the property, we'll put the property identifier number in here, and then below we'll put the legal description. Legal description is supposed to be written and shown on the listing contract and on the listing as seen on title. So I'm going to pull the title, I'm going to copy and paste directly into here so that we've done everything we need to do. Terms of sale. This is our listing price. So I've never had any terms written in, but the listing price goes here. So whatever price we agree upon, hopefully it's the market price, and we're working towards a sale at about market time, but we're going to agree on this listing price. I'm going to have a suggestion, and we're going to go from there. Listing service and cooperating brokerages. So the seller authorizes the listing brokerage to list the property, to publish in the MLS of the board, and to make agency disclosures required of the listing brokerage. Listing brokerage's remuneration. This is commission. One thing to note, when you read through here, it says if there's a certain situation where you were responsible for paying a commission, the only time you're paying a commission is if we have a sale. I don't get paid to get accepted offers that don't complete. I get paid for complete firm and binding contracts and you getting sold. So don't worry about any of that language up here. Commission that I generally charge, 7% on the first 100,000, 2.5 on the balance. The buyer's agent and their brokerage get 3.22% on the first 100,000 to 1.15% on the balance. My brokerage retains 3.78% on the first 100,000, 1.35 on the balance. And if there is no cooperating brokerage, meaning an agent from my office brings a client and writes an offer, then there's technically no cooperating brokerage because our brokerage represents both agents. Then full commission is payable because that's the only way that the buying agent gets paid. There will not be a scenario where I'm writing an offer for an unrepresented party and collecting full commission. I don't work with unrepresented parties. part of my duty to avoid conflict of interests. I don't feel comfortable with it. I don't think it's in the best interest of my clients. So anybody who comes in unrepresented, I refer them out to other agents to protect both you as the seller and myself as the listing agent. Our office, the listing brokerage, holds the listing and then distributes the commission accordingly and sends out what's called a CIR to both lawyers that determines who gets what commission and how. Designated agency. I will be your designated agent. And I can't designate, what part B here is important. The designated agent will not disclose to other licensees, including licensees of the listing brokerage who represent buyers or other sellers, any confidential information of the seller obtained through the designated agent's agency relationship with the seller unless authorized by the seller or required by law. So in the event that you have specific dates you need. So if we found a place you like and we need to try and line up dates and you say you can tell anybody who comes to our home that we want these dates. And if they give us these dates, their offer will be stronger than other offers. We're going to have a document written up that says I'm authorized to do that, and then I will do that. The only required by law is if there's any, if it's a stigmatized property, I will deal with that. If it is, I'll ask them the appropriate questions when I come and sit down with you. But most of the time we don't have to worry about that. The seller agrees that subject to an agency relationship will exist. Subject to item 3, an agency relationship will only exist with the designated agent. Information obtained by the designated agent through the agency relationship will not be attributed to the listing brokerage or other licensees. So our relationship is only us. My brokerage is kind of overseeing everything and going to help with the process, but they don't have any, I'm not disclosing to them anything that I'm not supposed to. This is a list of what the designated agent, that's me, will do. It's worthwhile having a quick read through. I won't go, it's fairly simple, so I won't go through it too much in detail. Similar to the listing brokerage agrees and the seller agrees. Have a read through these. If anything doesn't make sense, by all means, let me know right away. And the seller acknowledges and agrees. We're going to initial the bottom of all of these pages. This is the part that talks about conflicts of interest. The primary conflict of interest that will come up is, like I said, if I have a buyer who wants to purchase your property. And if that becomes the case, we have a couple of options. One is I say to my buyer, listen, I represent the seller in this process. I cannot work with you. Will you allow me to refer you out to another agent from our office for the purposes of writing an offer? If that happens, I can't disclose anything I've learned about that buyer to you through my agency relationship, because I have the same duty of confidentiality with them as I would have with you. So we would refer them out. I would sign a document saying I had represented both parties. You understand that I can't disclose to you anything about them, and they're now working with another agent. Everybody signs it, no conflict of interest. But however, if they say, no, you're working with us, and if I come to you and say, listen, these guys really want to work with me, and they won't write an offer otherwise, and we've had trouble getting offers, and these guys are ready to go, can I refer you out? Then we would do the same thing if you agreed, if I referred you to another agent. Now, if both of you say, no, we're only working with you, you're our guy, then I have to recuse myself from the deal and back out. And you both have to get new agents, and that's not fun for anybody. So hopefully that doesn't happen. Again, like I said, I haven't had that happen at all in my career to date, and I don't foresee it happening anytime soon. Item 13, collection, use of and disclosure of personal information. This talks again similarly to what privacy notice and consent, the previous document, talks about. Why we collect your personal information, what it's used for, who has access. Listing termination. If we decide to cancel, if you decide that you don't want to keep the property listed, if the relationship between us isn't working, we have the option to terminate. There are two ways we cancel. There's either cancellation, which means the listing is cancel protected. until the end of the listing, until the expiry date. So basically, we would take it off the market, but you couldn't relist it with somebody else until after the property, after the expiry date. There is also the option to terminate completely, but that is at the disclosure of my brokerage, and we would have to talk to them if you wanted to do that to make sure they were comfortable with it. Sometimes they are, sometimes they aren't, and that's kind of out of my hands. Miscellaneous provisions, a couple of different definitions. Again, nothing crazy in here. We're going to sign, seal, and deliver on this date. We will initial that we're residents of Canada. Seller's signatures go here. My signature goes here, and the signature of my managing broker goes here. And then that document is done. And like I said, it's fairly simple. Schedule A is where we would put any specifics that you either wanted me to disclose, or if we wanted to have a specific time frame for when we had our first showings. We're going to put that in the Schedule A here, and then it becomes part of and forms part of the contract. And we would initial the bottom page. So after those pages, the multiple listing contract is done, which is great. The next document is irrevocable direction regarding presentation of offers. So this is, as it says, irrevocable. It didn't used to say that on there. It only used to say direction regarding presentation of offers, and then you would, as a buying agent, you would call a listing agent, ask them when they're seeing offers. They'd say not till Monday, and then somebody would write an offer, send it over on Friday, and they'd sell the house. And everybody said that's not fair because it wasn't. And so now this is irrevocable. If we sign this and pick an offer date, we can't back out of that. We're not going to see offers until Monday. Review offers till Monday. Now I can show you any offer that comes in, but we can't accept until Monday. The other thing this form does is it gives us the option of attendance. So years ago in the industry, buying agents would sit down across the table from the listing agent and the sellers and present their offer in person. Most of my sellers, all but one, have not wanted this to be the case. If we don't have this form initialed here to say that we will only receive and present offers without the buyer's representation present, I have an obligation to allow them to do that. So that's why I'm showing you this form now, because we need this initialed so that the buyer's agent does not come, sit down across, and present the offer, because that can become uncomfortable. And if we're having an offer review date or time, if we've opted to list the property at a low price and work towards multiple offers, and we want to have an offer time and date, or if you're out of town when the property goes up for sale and you don't have access to internet or phone, we might not be able to review offers till Tuesday because you're not back till Monday night. So we would put the date, we would put the time, we would initial here, and then at the bottom of the document, we're all going to sign. Okay? Fairly simple. The next document is the property disclosure statement. I will send you over an email explaining how we're going to fill this out. It's a bunch of questions about your property, and what it's trying to figure out is it wants you to disclose any defects that may not be patent, which means easily visible or noticeable by an inspector. So if there's something behind the wall, if there's something on title that we don't know about, something like an unregistered easement. Let's say you own a property that's close to a lake, and you've been letting Johnny, your neighbor, walk across your property to the lake every day for the last 20 years. That is what's called an unregistered easement. He's been doing it with your permission. That can then be that can run with the property. So we need to know it, because if Johnny's been doing it for 20 years and you sell your home to Sam and Jean, then they may be obligated to provide that. So if you've been allowing any of these things, we need to know. And then you go right through, are there tenancies? It's a fairly monotonous document. We're going to, at least one of the sellers has to initial each of these boxes, and then everybody signs at the bottom. This is the detached property disclosure statement for strata properties. You would also have a section on there for who the property manager is, who the property management company is, what your strata fees are, what your strata fees cover, and what strata documents the potential buyers can expect to get from the strata package that I will be ordering. Okay, so this is another new one. And part of the reason I had to make a new video is because buyer's right of rescission came into effect last year. And what the buyer's right of rescission is in the event that somebody writes a subject-free offer, or let's say we get into a multiple offer situation and we get 5 or 6 offers. The strongest offer generally is the one that has no subjects. And previously it was firm and binding upon acceptance. So once you signed it and agreed to all the terms, their deposit was due and they were locked in. The government didn't think that was fair, and the reason is because when you get into a multiple offer situation, people get excited, they get nervous, there's fear of loss, and they may write a bigger offer than they wanted to, and they may have second thoughts, but by the time everybody signed everything, they couldn't back out. And so this, the right of rescission allows a buyer to back out of a deal within 3 business days of the offer being accepted. So on the contract of purchase and sale, which I don't have included here because it's not part of it, part of the listing package, but I wanted to include this document so everybody sees it. Basically, they have 3 business days from the date of acceptance, and then you will see that date here. So they're going to send when they disclosed it. This is the date of acceptance. 3 business days later will be listed here. There is a calculator on the BC Real Estate Association website, which a lot of agents use. It's advisable to use it, and the reason is because it takes into account weekends, holidays. You basically type in the acceptance, the exact time and date that you have it, and it tells you when the rescission period is up. The list offer price is listed here, and the reason is if the buyer opts to rescind, they need to pay a rescission fee to the seller. It is 0.25% of the offer price. So on an offer of, let's say, $1 million, the rescission fee would be $2,500. That rescission fee will also be listed here. On the purchase contract, we're also going to list a contact person in the event that they do rescind. There's a document they have to send notifying a written notice that they are rescinding, and then they have to submit the rescission fee, or if they put in their deposit already, the rescission fee comes out of the deposit before it is released back to the buyer. So everybody's gonna learn about this. We're all gonna know date provided, licensee name and signature saying I've shown you this, clients' names, client signatures, and that's your listing package. It's fairly simple. The contract of purchase and sale for buyers is a lot more difficult. I have that video as well, and I will be sending that to you just so you can have a review of the contract as well prior to receiving offers, because by the same token, it is very detailed, and in the event that we have one offer or more offers, I want to make sure that we have the time to review all the meat and potatoes of those offers and go through those in detail, as opposed to going through all of the 13 pages of legalese. Thank you very much for watching this video. Let me know if you have any questions, and I really look forward to listing your property.